and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? Yes.
That was Maya Kowalski as the verdicts were read in her civil trial against Johns Hopkins All Children's Hospital in late 2023. A jury awarded her more than $200 million, but an appeals court has put the brakes on that award and ordered a new trial. I take a look at the opinion and what could come next. I'm Angenette Levy, and this is Crime Fix. If you ever get hurt, you might need someone in your corner to fight for you, and Morgan & Morgan can do that. The firm has more than 1,000 lawyers on its team because they are big winners. They've recovered more than $25 billion for 500,000 clients. In the last few months, a client in Florida got $12 million after the insurance company offered just $350,000. In Pennsylvania, a client was awarded $26 million. That was 40 times the insurance company's $650,000 offer. Another client in PA got $29 million after being offered $500K. So even if you think your case is not worth millions and millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it really easy. You can start a claim in just 8 clicks on your cell phone. So if you're ever hurt, start a claim at forthepeople.com/crimefix or scan that QR code that you see right there on your screen. Maya Kowalski's case made headlines thanks to Netflix and that 9-week trial in which she sued a children's hospital in Florida, which was very widely viewed. In case you're not familiar with Maya's case, let's start at the very, very beginning. In 2015, Maya was 9 years old when her health deteriorated significantly. She was diagnosed with CRPS, that is complex regional pain syndrome, a neurological condition where a person's body can misinterpret even light touches as excruciating pain. It can cause stiffness, spasms, and limited mobility. It really sounds awful. In the family's eventual lawsuit, which we'll talk about, they use words like burning, bone crushing, shooting, and stabbing to describe what Maya was feeling. The family's doctor treated Maya with ketamine infusions, which it's our understanding can block someone's pain receptors and try to normalize the body. Apparently, it's not a miracle cure, and there can be flare-ups, but some doctors believe it can help, and Maya's doctor was one of those doctors. And according to the Kowalskis, that's what happened in 2016. Maya had a flare-up, and so Jack and Beata, Maya's parents, checked their daughter into Johns Hopkins All Children's Hospital. Beata told the hospital to treat Maya with ketamine because it had worked for her in the past. But according to the lawsuit, the hospital staff refused to follow the family's instructions or the guidance of the family's doctor. The family says the hospital staff didn't have experience with CRPS. The family claimed hospital staff were suspicious of Maya's family because the ketamine treatment seemed really extreme. In fact, the family argued that the hospital suspected Maya might be the victim of child abuse and that this was a case of Munchausen syndrome by proxy, basically saying that Beata was suffering from a condition in which she was faking or causing her daughter's illness. The family alleged that a hospital social worker contacted the Florida Department of Children and Families to report Beata and refused to let Maya leave the hospital. Maya was taken into state custody and remained in the hospital, and she didn't see her family for 3 months. Maya told People magazine that she was medically kidnapped. She claimed the hospital not only ignored her wishes and misdiagnosed her, but mistreated her, harmed her, and caused her extreme emotional distress. In fact, there was an allegation that an employee may have even inappropriately examined Maya. This separation took a massive toll on Maya's family, resulting in Beata's depression, fatigue, and overwhelming sense of hopelessness. In January 2017, Beata Kowalski apparently couldn't take it anymore and decided to end it all. She made the choice to end her own life. The Kowalski family story was documented in the Netflix series Take Care of Maya, watched by millions of people. The Kowalskis sued the hospital for medical malpractice, claiming medical negligence, false imprisonment, and battery of Maya, as well as intentional infliction of emotional distress. They also argued fraudulent billing of Jack, an infliction of emotional distress of Beata, and a wrongful death claim. The goal was to determine whether the hospital engaged in wrongdoing and therefore contributed to Beata's death. Attorneys for the hospital didn't roll over. They argued the hospital staff and doctors acted reasonably and were looking out for Maya's best interest. The case went to trial in 2023. And Maya testified.
The nurses and doctors wanted to put a tube down my nose. And with CRPS, a blood pressure cuff, that hurts. So imagine, like a tube being shoved down your nose into your stomach. And obviously, that would have caused so much pain. And I knew my body. I knew I was not going to be able to tolerate that. That is the only time I asked for sedation. I didn't just randomly yell out, "I need sedation," like depicted in the medical records. I only asked for sedation when they wanted to do that procedure.
And then, were you given sedation before they tried to put this tube down your nose?
I was not, and my mom was actually in the room, and she listened to the doctors and didn't demand for sedation. Instead, about I would say 2 or 3 people held me down and tried to get the tube down my nose. That is when I was screaming, crying, and thrashing around.
Maya also testified that she was being isolated during her time at All Children's. Take a look.
So her mom was there with Natalie, the friend that I had made, and I was wheeled over there and I talked to them. Another nurse observed this interaction and quickly told somebody. Next thing I know, Kathy Beatty is in my room saying I'm not to ever speak to a patient again. And that day, Natalie had given me this little present because her mom noticed my parents were never with me. I think they just wanted to comfort me, and I have it in my bag today.
Did they ever give you any reason why you, as a 10-year-old, couldn't just talk to the kid next door, for lack of a better term?
I have no reason. They didn't give me any reason.
The jury then heard gut-wrenching testimony from Maya about the last time that she saw her mom.
My mom was picking up her work bag and just little things she had brought to the hospital. And she said, "I love you and I'll see you tomorrow." And I never saw her again. But I bought my mom this very specific necklace that says "I love you to the moon and back." It's just she always said that to me. And then I found out later that she wore it every single day. And when she was found in the garage, she was still wearing it. And I have it on my neck right now.
In the end, the jury sided with Maya.
We, the jury, return the following verdict in regard to punitive damages. Claim 1A, false imprisonment between October 7th and October 13th, 2016, Maya Kowalski. 1. What is the total amount of punitive damages, if any, which you find, by the greater weight of the evidence, should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 7th and October 13th, 2016? $15 million.
The total in damages the jury awarded a whopping $260 million. $50 million of it was punitive damages. That was eventually reduced to $213.5 million. In December 2023, I spoke with Maya and her lawyer and asked her how she was doing.
Well, I think it's pretty obvious that I'm definitely doing a lot better than I was when I was 10, but that doesn't mean I don't face challenges. Even people in wheelchairs from the neck up, they look completely normal. So it's kind of hard to gauge just by looking at somebody, and I think that's important to keep in mind. But I do still struggle, as you said. I have the same burning pain. I get lesions, and I also suffer from different temperature changes that are so significant that, even friends who hug me ask, "Oh, why are you so hot?" or "Why are you so cold?" So it's very apparent that it's still there, but I just have to take every day, slowly.
All Children's Hospital vowed to appeal after being denied a request for a new trial, and now the appeals court has ordered a new trial, citing a number of errors by the trial court judge, including rulings on immunity conferred upon All Children's Hospital for reporting suspected child abuse. The opinion cites Section 39 of the Florida statute. Any person, official, or institution participating in good faith in any act authorized or required by this chapter, or reporting in good faith any instance of child abuse, abandonment, or neglect to the department or any law enforcement agency shall be immune from any civil or criminal liability which might otherwise result by reason of such action. The appeals court called the case emotionally charged and pointed to other providers' concerns about psychological factors possibly impacting Maya's health. The opinion states, evidence established that prior to Maya's admission to JHACH in October 2016, concerns had been raised about psychological factors affecting Maya's physical condition by medical professionals who had treated Maya at Tampa General Hospital and Lurie Children's Hospital of Chicago. The court further explained that Maya's condition appeared to improve during her treatment at All Children's. During the months that Maya was sheltered at JHACH, she was weaned off ketamine, and the dependency court order releasing Maya from JHACH prohibited additional ketamine treatments. Maya had been admitted to JHACH in severe pain, unable to walk, and receiving high doses of ketamine. When she was discharged from JHACH, she was still in significant pain and unable to walk. At the time of trial, the only medications she routinely took were Claritin, Flonase, and a sleep aid. She had been able to walk, run, and ice skate. Maya testified that she had experienced no CRPS flare-ups in the 3 years following her January 2017 discharge from JHACH. The appeals court opinion also cited another error the court made when it came to Maya Kowalski's claim that she was falsely imprisoned. Although our reversal of the judgment as to the October 7th through October 13th false imprisonment claim moots the issue specific to that claim, we would have otherwise concluded that directed verdict was warranted as to punitive damages because JHACH's actions during that period do not meet the definition of either intentional misconduct or gross negligence. Directed verdict is a motion made by a party in a civil case where they ask that a case be dismissed for lack of evidence. The appeals court said that motion should have been granted at several points during this case. The appeals court also called the closing argument given by the Kowalski's attorney inflammatory. A footnote states, the closing arguments were also inflammatory. Counsel for the Kowalskis argued that JHACH took Mrs. Kowalski out of the game by changing its diagnosis and treating the Kowalskis like criminals. Counsel then went through JHACH's defenses because if we get rid of the defenses, then all that is left is the Kowalskis' case. Counsel for the Kowalskis argued that something happened between Mrs. Kowalski and JHACH that ticked JHACH off, causing JHACH to call the department, and that JHACH was not going to let this brusque lady with an Eastern European accent come in and tell them how to do their job. They argued that JHACH calling the department hotline was retaliatory against Mrs. Kowalski and that she committed suicide because she knew that if she did not take drastic action, Maya would end up in some kind of foster care or die. The Kowalskis claimed hospital social worker Kathy Beatty made incredibly inappropriate comments to Maya and her father about Beata Kowalski, such as telling Maya that her mom was in a mental institution. Jack Kowalski testified that Beatty asked him if he had considered divorcing his wife, and then Maya testified that Beatty told her, "I'm not trying to be your mother, but I can be." The appeals court determined Beata Kowalski wasn't present when those remarks were made, so it didn't meet the standard for intentional infliction of emotional distress. But the court determined that Maya's claim of intentional infliction of emotional distress met the standard of outrageousness because of her age and her status as a patient. She testified that social worker Beatty would say things to her about her mother, and nurses would talk about her mother causing her symptoms within earshot of her. One judge wrote, however, even after stripping Maya's IIED allegations of the offending claims and immunity, entitled evidence, there remains competent substantial evidence supporting the trial court's findings that Maya's IIED claim met the high bar of outrageousness. These healthcare providers were in charge of caring for and treating Maya. Instead, they exploited their positions with full knowledge that Maya, a 10-year-old child, would not be able to endure such outrageous conduct and undoubtedly suffer severe emotional distress as a result. So the appeals court threw out the judgment to Maya by the jury. The final judgment in favor of the Kowalskis is reversed. On remand, only the IIED claim brought on behalf of Maya and the remaining false imprisonment, battery, and medical negligence claims may be retried. The attorney for Johns Hopkins All Children's Hospital issued a statement about the opinion reversing the jury's award. This opinion sends a clear and vital message to mandatory reporters in Florida and across the country that their duty to report suspicions of child abuse and, critically, their good faith participation in child protection activities remain protected. We thank the judges for their time and attention to this matter, and we appreciate that they understood what many did not, that a one-sided movie is no substitute for a fair judicial process. So to discuss this decision from the appeals court, I want to bring in Greg Anderson. He represented Maya Kowalski and her family at the trial 2 years ago. So Greg, welcome back. Thanks for joining me. Tell me, if you would, your reaction to this opinion. I know you're no longer representing Maya, but you represented her at trial. And so they basically gutted the verdict in this case.
Oh, Angenette, it's good to see you again. It's been over a year now. And last time we talked was right after the verdict. And of course, we were all very happy about that. I think we talked in December of 2023, and the verdict came in November. To me, let me say that legally it was a shock. Practically, it was not outside the realm of things I had considered could happen, given the circumstances post-trial. So, I've only had a chance to read the entire opinion once. I have been trying to discern the second district panel's rulings on a number of issues involving Chapter 39, which is the reporter statute, the child abuse statute in Florida. We got retained in 2017, so I had spent 7.5 years analyzing that statute and every conceivable case and interpretation of that statute. And I know that Judge Carroll had done the same and more. I can't even imagine the number of hours he spent analyzing the law on that. Just did a brilliant, brilliant job. And so to read the opinion was, from the legal standpoint, at times confusing, at times astounding. There wasn't much on the key legal issues that I agreed with, but obviously, I had brought the case and developed the case for 7 years and tried the case.
Well, they basically said that the hospital had immunity. They suspected child abuse, and so they reported it to the hotline, and then the court got involved, and the court implemented orders, and that the hospital was basically implementing the orders conferred upon them by the court. The court said, supervised visits with Maya's mom, etc. And there was going to be this trial, and sadly, Maya's mother took her own life the day before that trial was to begin. So, I'm reading through all of this. It's 46 pages, 47 pages. And they did say that sounded like there was intentional infliction of emotional distress on Maya, and that should be, looked at and retried and evaluated. It sounds like it was outrageous conduct, the court believed, but they gutted everything else. So what do you, as a former lawyer of Maya's, see possibly happening here? I mean, do you think this case will ultimately be retried, or, I know you don't have a crystal ball, but do you think it gets retried, or do you think it gets settled?
Well, there are actually 4 causes of action that survived. And it's important to note that Judge Carroll had planned for this contingency of different rulings he made on Chapter 39, which I think we all agree is a difficult statute. I hope that the legislature does something about that. There have been some attempts to change the legislation, so far unsuccessful. So there are a number of causes of action, all directed more or less towards Maya, that are going to be retried and reset by the court. The decision on whether to retry it, I think, if I were them, I would be moving for rehearing based on the way that the court set up the verdict form, because Judge Carroll, foreseeing that maybe the second district wouldn't agree with everything he did, made each one of the acts of wrongdoing its own little mini trial. So the jury was asked, was there false imprisonment? Were there any defenses to it? Did it proximately cause injury or damage? And if so, what were the injuries and damages strictly related to that one event? And the idea being that in the event that the second reversed on one or more of the particularities because of Chapter 39, that there would be no need for a retrial. You've already had a trial on that particular issue. And the jury was specifically instructed over and over that they are to disregard other events and focus on this one event for this one section of the verdict form. You see? So it was a very long verdict form. I forget how many, I'm sure I'm going to get this wrong, but I thought it was over 50 pages of verdict form and many, 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 many questions.
Mm-hmm.
So my hope for the sake of the family, regardless of how Jennifer and I have been treated, would be that on rehearing, the second looks at what Judge Carroll did and reconsiders whether those need to be retried. Because I just think it's already been done once before, and it was so well segregated out by the trial court. There's no reason to put the family through it again. There's no reason to put the court and the judicial system and the taxpayers through it again. But, I don't write the law or even decide the law.
Interesting. There was one last point. The appeals court said, that the closing arguments were inflammatory. What is your response to that? Because, they're basically saying the judge screwed up at every turn. I mean, that's how I read this opinion.
Which is strange because Judge Carroll is considered, from my reading, for instance, he was just appointed the head of the 12th Circuit's complex litigation section. He was chosen by his fellow judges to be the most, if you will, intellectual and best able to deal with complex issues. And so I think it's going way overboard to say that he screwed up everywhere. I don't think he screwed up anywhere on this. I have my own personal feelings about how this came down, and I was there at the oral argument and I saw the questions asked. To get to your point on my closing, the first thing to notice is that it was a footnote.
Right.
It was not in the body of the decision, and therefore it was not part of any decision of whether to retry the case or not. And here's another huge problem. There were no objections during the closing.
Mm.
And for 250 years, our republic and 100 and what is it now, 60 or 80 years of our state has required that if you disagree with something at a trial, you must object. And the trend in the past 20 years has been you should move for a mistrial to give the trial court the chance to preserve the trial and to correct any wrongdoing, a corrective instruction. Mr. Anderson, maybe you went too far over there. Maybe, ladies and gentlemen of the jury, that's hyperbole. I ask you to disregard it. Those kind of instructions. And they're brought about because the defense feels that there's something that first is objectionable, right? So they stand up and say, I object, which they didn't. Second, if it's really objectionable and they think it could affect the whole trial, then they're to move for mistrial, which they didn't do. And they didn't really even raise it in their briefing. And again, I want to say this, I haven't been back through all of the briefing. Maybe I'm wrong, maybe they did bring it up there, but reading back through it the last time, I don't remember that being a focus at all of their appeal. So it was, however, brought up by some of the amicus curiae, that is friends of the court, which are the industry, the Florida Hospital Association and Children's Hospital Association. They basically had about 4 bites at the apple with different associations writing friend of the court briefs. And they did bring it up. The final thing I'll say about it is that this case involved punitive damages. And I went back last night And I pulled every decision I could find from the Second District Court of Appeals, and I noted that there wasn't any case law cited about what I said or did in that footnote. It was just, I went overboard. But then I recalled that this was a punitive damages case, and there are, by my count, at least 7 decisions that specifically say that in punitive damages cases, counsel is given much wider latitude in making arguments.
Greg, we're going to keep a really close eye on this and see where the case goes from here. Thank you so much for joining me. I appreciate it.
Thank you for having me.
And we will keep a close eye on this story as it moves forward. That's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.